Dear colleagues and friends, it's my pleasure to welcome you to another episode of Ciarb in Arabic podcast, where we host thought leaders in international arbitration. Our guest today is Gary Bórn. Gary is a partner of Wilmer Cutler in a special episode titled International Arbitration in the 21st Century. Gary Bórn is the chair of the International Arbitration Practice Group at Wilmer Cutler and the world preeminent authority on international commercial arbitration and international litigation. He has served as a counsel in over 675 arbitrations, including several of the largest arbitrations in the ICC and ad hoc history. And also he has sat as an arbitrator in more than 250 institutional and ad hoc arbitrations. Mr. Bórn has published a number of leading works on international arbitration, international litigation, and other forms of dispute resolution. He is the author of International Commercial Arbitration, 3rd edition, the leading treatise in the field, which has received the American Society of International Law's Certificate of Merit of High Technical Craftsmanship, and OGEMID Books of the Year Award for 2009. He is an honorary professor at law of the University of St. Gallen, Switzerland, and Tishigo University in Beijing, and teaches regularly at law schools in Europe, Asia, and North and South America. Mr. Bórn is a former president of the Singapore International Arbitration Center, SIAC, Court of Arbitration, a member of the International Advisory Board of the Hong Kong International Arbitration Center, HKAIC, and a member of the International Arbitration Committee of the Korean Commercial Arbitration Board, KCAB. Also a member of the Global Advisory Board of the New York International Arbitration Center, NYAIC. Among many accolades, Mr. Bórn has received the Global Arbitration Review Inaugural Advocate of the Year Award, the Client Choice Award for the Best International Arbitration Practitioner, and the Best Lawyers London Arbitration Lawyer of the Year Award. He is one of only 2 practitioners in London and globally to achieve a starred status for international arbitration in the Chamber's guides. In 2008, Chambers recognized him for his outstanding collaboration to the legal profession, describing him as the world's foremost authority on international arbitration and litigation, in a class of his own, and revered around the world for his work on international commercial and investor arbitration. Mr. Bórn also is the author of The File, which is a best-selling spy thriller. So I would like to welcome him today. Gary, welcome. And it's our pleasure to host you today.
Thank you so much, Saad, and in particular as well, thanks to Ciarb in Arabic. It's both an honor and also a pleasure to be here with you today.
Thank you so much, Gary. So let's dive into our discussion today. And to begin, I would like to explore with you the global perspective on arbitration. So as you know, Gary, the law often reflects the culture and background. And I would like you, if you can, could you take us on a global journey to identify how do you see the various jurisdictions perceiving the arbitration, and also with insights into their specific approach?
That's a great question, Saad, and it's one that I think helps illustrate the unique character of international commercial, also international investment arbitration in our era in the 21st century. On the one hand, arbitration, international arbitration, both commercial and investment, is uniquely global. International commercial arbitration has a global constitution, an international constitution. It's, of course, the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the so-called New York Convention. It has almost 170 contracting states that are party to it, and it provides the international legal framework for international commercial arbitration. All those contracting states, 170 or so, every significant economy in every geographical part of the world, have acceded to the New York Convention. And for the most part, not perfectly, but for the most part, they faithfully apply its requirements. Similarly, on a national level, almost as many countries, not quite as many countries, but almost as many countries have either adopted the UNCITRAL model law on international commercial arbitration or some variation of it as the basis for their national arbitration legislation. And so, again, one has international instruments providing the fundamental legal framework for international commercial arbitration. The picture is at least as international, perhaps a touch more, in investment arbitration. The ICSID Convention, to which almost as many countries are party as the New York Convention, provides both a global international constitution for the conduct of investment arbitrations, but also an autonomous international regime largely detached from national courts. Even in investment arbitrations where the ICSID Convention does not apply, and there are a good number of those, the New York Convention and the model law, the UNCITRAL model law, do apply. And so once more in the field of investment arbitration, one has a profoundly and in some sense almost uniquely international legal framework for arbitration. It's not a framework that's shared in most respects by other types of agreements, other types of contracts. Most commercial contracts, insurance policies, or joint venture agreements, share acquisition agreements, shareholders agreements, the whole vast panoply of other types of commercial contracts don't have that international constitution, that international legal framework. And so in that sense, international arbitration is profoundly international in its legal framework and also in its practice profoundly international. There are common soft law principles, whether it's the IBA rules on the taking of evidence or guidelines on conflicts of interest or rules with respect to party representation. All of these, as well as if I can put it this way, a culture of the practice of international arbitration make it a uniquely international field, so that an arbitration seated here in Doha under the KICA rules won't be fundamentally different from a AAA arbitration in New York and LCIA arbitration in London and SIAC arbitration in Singapore. There's a true commonality and international character to arbitration. At the same time, one shouldn't neglect the national character, the cultural characteristics, the language characteristics of specific arbitration.
My follow-up question, since we spoke about Doha and the historical, characteristics, so we have now different jurisdictions, and how have different jurisdictions actually developed their arbitration frameworks? What historical, cultural, or economic factors do you think it's influenced this development? Specifically, we are now, for example, shooting in Arabic in Doha today. So,
in addition to the international legal framework, which I've described, the New York Convention, the ICSID Convention, the model law, and also a sort of common law of international arbitration where courts in one country, the United States, look to decisions elsewhere, United Kingdom, Singapore, or Indian courts look to English courts or Singaporean courts, or vice versa. Inevitably, national characteristics arise. The most obvious example is with respect to language. In some cases, parties may choose to arbitrate in Spanish or Arabic or Mandarin or something other than English. They say, of course, that the most widely spoken language in the world is bad English. And I do think that English continues to be the most frequently used language for international arbitration. But certainly in particular regions in the world, think Spanish in Latin America, although even there, Portuguese and English are strong contenders. Think Mandarin, perhaps, in the Greater China region. Think Arabic in the Gulf and elsewhere. Influence the arbitral process very significantly. Equally, I think quite importantly, the relations between counsel, how it is that lawyers deal with one another, has a very important influence on the arbitral process. And therefore, if you have two Qatari law firms, it's a very different arbitration than if you have two English law firms or two French law firms or a French and a Swiss law firm. I think the character of counsel, the identity of counsel in cases plays a hugely important role in how the arbitration procedure actually unfolds. And the same, of course, is true with respect to the presiding arbitrator or the arbitral tribunal overall. The cultural aspects of the arbitration are hugely important alongside the substantive legal rules.
Okay. طب linking this to the emerging markets, since we make a comparison now, how do these jurisdictions perceive the arbitration compared to more the established one? And also, what the challenges do you think that they face in promoting the arbitration?
Again, I think there's a remarkable similarity in views, regardless of the country or jurisdiction that one is in, regarding international arbitration. I think that common international legal framework, New York Convention, ICSID Convention, contributes to that, as does the international character of those who practice international arbitration. I think inevitably countries that have more experience with arbitration, or in a sense it's not even countries, locations, major commercial centers, London, Paris, New York, Singapore, that have significant experience with arbitration may have more nuanced views, in a sense, may see areas where they perceive a greater need for change or reform. I think in jurisdictions with less experience with arbitration, there oddly tends to be a more unnuanced enthusiasm about arbitration without a sense that there may be areas where it needs to be improved or reformed. There's more of a sense that it is a new opportunity to participate in an evolving world economy, and one should embrace it wholeheartedly and without reservation, whereas ironically in some of the more developed. And so as a consequence, a little bit ironically, I think in some jurisdictions where arbitration is a bit newer, there is more unqualified enthusiasm for it. I think it's important that we always recognize that arbitration is a creature of the parties' agreement. And as a consequence, it is subject to the parties' continuing wishes, in particular, how to reform it, how to make it better, how to make it stronger. The ICC revises its rules. The International Chamber of Commerce revises its arbitration rules every 4 or 5 years. Other institutions do the same, not because there's anything fundamentally wrong with those rules as the starting point, but because one always can take the opportunity to improve the process. Users inevitably today want things faster, but also cheaper, and also at the same time better. And satisfying those three somewhat conflicting demands can be challenging. And both in developed and also developing jurisdictions, meeting those challenges is what's important.
Finally, last question on this part. In your experience, which countries or region are currently trying to make a significant strides in becoming an arbitration friendly, and what also the factors to contributing to this or to their growth?
So in a sense, the answer to the first part of the question is every part of the world is trying very hard to improve its international arbitration practice, the opportunities it offers, and for good reason. International arbitration provides a means of enhancing cross-border commercial transactions, which most states see as quite significantly in their interest. It contributes to the local legal community and ultimately to the rule of law. And as a consequence, I think everywhere is trying with some degree of effort to improve the international arbitration regime, to create more opportunities for international arbitration. Areas where one has seen that in particular in the past have been Asia. Singapore, to a lesser extent, Hong Kong, have made quite serious efforts over the last 30 years. And in Singapore's case, with very significant success. I think Hong Kong's future is much more doubtful, but Singapore has certainly achieved quite substantial success. Here in the Middle East, Bahrain was an early leader in alternative dispute resolution, followed, however, quite closely by the UAE, both Abu Dhabi and Dubai. In Abu Dhabi, the ADGM and now Arbitrate AD have made a real splash on the scene. Dubai with currently DIAC. And here in Qatar, KICA has been quite significant in recent years. Saudi Arabia, of course, is the perennial elephant in the room, if I can put it that way. And the Saudi Center will no doubt be a formidable competitor for international arbitration in the region. At the same time, I would hesitate to neglect the traditional centers, whether it's London or Paris or New York, increasingly Miami in the United States, focused on Latin America, have all sought, if I can put it this way, to up their games.
Moving from the global trends now to the core of arbitration itself. So let's discuss, for example, the arbitration agreement and the question of consent. So my question here would be, when there will be a dispute over consent or the substantive validity of the agreement, should this be determined by the courts or the arbitral tribunal?
That's a great and a perennial question that
I had to read a lot to prepare for this interview.
You've prepared quite well. It's a perennial question that both courts, arbitral tribunals, and commentators frequently grapple with. Of course, as you quite rightly say, Saad, the foundation for international arbitration is the arbitration agreement. And by that, of course, we mean a valid agreement which is binding on the parties, committing them, obligating them to arbitrate their disputes instead of sending them to state courts, to national courts. The question, who decides whether an arbitration agreement exists, whether it's valid, what it extends to, what its scope is, as I mentioned, a perennial question. And different national legal regimes with entirely plausible justifications have reached quite different results. In France, the historic view and the continuing contemporary view is that this question, the existence, validity, scope of the arbitration agreement, is a matter in the first instance for the arbitral tribunal, subject only later to national court review. And so the answer in France to your question is the first place, without fail, for the validity, existence, scope of the arbitration agreement to be decided is by the arbitral tribunal, but subject to a de novo subsequent review by national courts. There are very limited instances in which a court can instead first decide the issue, but that's only if it is manifestly clear, obviously apparent, that there is no arbitration agreement or that its scope is quite limited, not extending to the parties' dispute. But that is very, very seldom invoked by the French courts. A number of other courts have followed largely in French footsteps. The better view is that that's the conclusion that has also been adopted in places like Canada, India, Singapore, perhaps elsewhere. In contrast, other countries, a good example is Germany, but one can also look to the United Kingdom and to some U.S. decisions, reach exactly the opposite conclusion. Their conclusion is that at least when the existence of the arbitration agreement is challenged, that is a question for the court in the first instance, and one can seek a judicial decision before the arbitral tribunal decides. In those cases as well, even where the arbitral tribunal makes an initial decision, it is subject to subsequent national court review. And then finally, some courts, and this is my own personal preference, take an intermediate view. They take a view that in many cases it's appropriate for the arbitral tribunal, particularly if it has already been constituted and is there available to hear the parties' jurisdictional dispute. The arbitral tribunal should first exercise its competence to decide the jurisdictional dispute, existence, validity, scope of the arbitration agreement, subject, of course, to subsequent national court review. In some cases, for example, if no arbitral tribunal has been constituted at all, or if for some reason the issues concerning the jurisdictional challenge are peculiarly within the competence of national courts, then a national court might first decide. But in many cases, it will be more efficient, and in my view, more helpful, more constructive for an arbitral tribunal to first consider the issue of jurisdiction. I say more helpful and more constructive because often the arbitral tribunal will have particular commercial expertise in the underlying field of the parties' dispute, say, construction or insurance. And that expertise can be quite important in some cases in deciding the jurisdictional questions. And equally, the arbitral tribunal has presumptively greater expertise in the arbitral process itself, as well as interpreting and applying arbitration agreements. And thus, from an efficiency and expertise perspective, allowing the arbitral tribunal first to decide the jurisdictional issue, subject to subsequent national court review, is the better course, although there may be important exceptions.
In the case of the tribunal decision or the arbitral tribunal deciding, which law actually would govern the question?
So ordinarily, and looking to the UNCITRAL model law on this, one would be considering Articles 8 and 16 of the model law. They are somewhat opaque, both on the question that I just answered, namely who decides first, and also on the question that you have just asked, namely what law applies. In principle, one looks to the law governing the arbitration agreement, which the model law is also relatively silent with respect to. It has a provision on choice of law, Article 28, but that applies to the choice of law governing the merits of the parties' dispute, the law governing their underlying commercial contract, not the law governing the separable arbitration agreement. My own view is, of course, the law governing the arbitration agreement is the law chosen by the parties, but in the vast majority of cases, parties do not exercise that autonomy to choose the law governing their arbitration agreement. And by that, I emphasize they're separate, they're autonomous arbitration agreement. Parties quite frequently have a general choice of law clause, which chooses the law governing their underlying contract. But in my view, and in I think the view of the better reasoned authorities, the general choice of law clause does not typically extend to the separate arbitration agreement. And there are profoundly compelling reasons to, when looking at the law governing the separable arbitration agreement, apply the law chosen by the parties as the arbitral seat. The arbitration agreement has a much closer connection to the arbitral seat than it does to the underlying commercial contract and its choice of law. And thus, in selecting the law to govern the separable arbitration agreement, the better choice in the vast majority of cases is the law of the arbitral seat. And as a consequence, one would look to the law of the arbitral seat to decide, is there a valid arbitration agreement? What is its scope? That makes particular sense, I would suggest, because it is in the arbitral seat that national courts will most likely reconsider issues of jurisdiction that have been decided by the arbitral tribunal. They'll do so either under Article 16 of the UNCITRAL model law or under Article 34 of the model law and parallel provisions of most other national arbitration legislation.
Continuing on the same theme, in the cases involving, for example, mistakes or internally contradicting arbitration agreements, would such an issue also affect consent and also ultimately the validity of the arbitration agreement?
Absolutely. One of the early Secretary Generals of the ICC Court of Arbitration, the International Chamber of Commerce Court of Arbitration, Frederick Eisenman, wrote a famous law review article, if indeed law review articles can be famous, a famous law review article about pathological arbitration clauses. And by this, he referred to arbitration clauses that have, as you put it, mistakes or inconsistencies. There are many examples of such clauses, which I think owe their existence to the late night drafting of many arbitration clauses. It's legend that arbitration clauses are typically drafted at 11:30 p.m. in the evening just before signing. It's the last thing commercial parties and their lawyers think about, and thus they tend, it is said, to be sloppy. Experience certainly confirms that in many cases you have poorly drafted arbitration clauses, which, for example, can refer to non-existent arbitral institutions that never existed, or to institutions that used to exist but don't exist anymore, or alternatively to two different institutions without clarifying or indicating how those two institutions are to coexist or cohabit, or perhaps to both arbitral institutions and national courts. And Eisenman described all of these clauses as pathological clauses, which, in his words, and I do quote him now, belonged in a museum of dark monstrosities, and that weren't even worthy of the name arbitration agreement, much less being enforced as valid arbitration clause. I take a different view. I don't see these mistakes as monstrosities, monsters to be put in some dark museum. I instead see them as patients who need to be taken care of, need to be taken care of in order that their mistakes be remedied. And I believe this is entirely possible, but also consistent with what national courts have done. National courts have looked at, for example, clauses that refer to non-existent institutions and tried to make sense out of them. Not put them in a dark museum, but tried to understand what the parties really wanted. And what courts and arbitral tribunals in these cases have usually done has been to correct misreferences. If the parties refer to the International Commission of Commerce instead of the International Chamber of Commerce, they correct that. They correct that reference to what it is the parties in all likelihood meant. If the parties refer to an institution that no longer exists, but there is a successor institution, they will interpret the parties' agreement as being to arbitrate under the rules of the successor institution. If the parties refer to two arbitral institutions, they will try to give meaning to that. For example, by permitting the claimant in the case to choose one of the two institutions, or to have one institution's rules apply as the procedural rules, the other institution to act as the appointing authority. And in those ways, national courts have sought to give effect to even the most pathological of clauses. Their rationale has been that in these cases, the parties' predominant intention has been to arbitrate their disputes, not to litigate them. And thus, even if there are errors in their expression of exactly how they wish to arbitrate, one needs nonetheless to give effect to the predominant motivation that they had, the predominant agreement that they had, which was to arbitrate instead of to litigate. In an extreme case, it can mean that an arbitration clause providing for arbitration under the rules of an institution that has ceased to exist, that is now non-existent, simply turns into an ad hoc arbitration agreement. You blue pencil out the reference to the non-existent institution, but you respect the parties' agreement to arbitrate, even if not in precisely the way that they prescribed.
Going back to the tribunals, can you please share with us some notable cases that you have dealt with over the disputes, like over the consent itself? And can you highlight also the key factors in these cases the tribunal considers when determining whether an arbitration agreement is valid and binding or not?
Naturally, I need to be mindful of obligations of confidentiality in international commercial arbitration in particular, somewhat different rules with respect to investment arbitration. I can, however, say that the key factors are, on the one hand, the evidence in any particular case. Every contractual relationship, every asserted contract is unique. They're like snowflakes, or like people. Each one is different and unique unto itself. And the key factor in many commercial cases is, what is it that the parties said to each other, often in the form of writing, and in the 21st century, very often in the form of electronic writing, electronic communications. What is it they communicated to each other? And that inevitably will be the starting point, often the ending point of the tribunal's analysis. Also critical, of course, is the applicable set of legal rules, which takes us back to the choice of law question I described previously. But one looks to, at least if my preference is accepted, the law of the arbitral seat for the legal rules governing the existence, the validity, and also the scope of the arbitration agreement. Importantly, I have said and continue to believe, in my treatise in particular, my commentary on international commercial arbitration, that national law is subject to the New York Convention and its requirements in Article 2 in this respect. And therefore, one must look to the Convention's requirements that contracting states give effect to agreements to arbitrate. But those two sets of factors, the evidence and the law, are what determine issues of consent.
So lastly on this part, drafting the arbitration clause is a critical step as we discover now from this discussion. So how important is the careful drafting in avoiding disputes related to consent, and also what the common pitfalls should parties avoid?
That's a great question. As I said in a previous answer, national courts and many commentators, myself included, have been very forgiving of pathological arbitration clauses, even if parties make mistakes, have inconsistencies or contradictions. The courts try to give meaning to their contract, try to give effect to what they conclude a valid arbitration agreement is. That doesn't mean that you should draft bad or pathological arbitration clauses. Just because somebody may rescue you doesn't mean that you should jump into a raging river. And in fact, it's quite important to draft carefully good arbitration agreements, not pathological clauses. Happily, the recipe for doing so is not very complicated. And in fact, I often say that the right way, the right motto to use in approaching the drafting of arbitration clauses is KISS, K-I-S-S. Keep it simple, stupid. Many people, many corporate lawyers, other lawyers for that matter, see the drafting of an arbitration clause as an opportunity to use their creativity, to take out their pen and to use it for some period of time. One sees arbitration clauses that go an entire page or several pages, sometimes an entire standalone agreement. I would counsel against that. I would counsel instead in favor of KISS. Every arbitral institution has a model arbitration clause. All those model arbitration clauses are on their websites. You can look, whether it's KICA or Arbitrate AD, whether it's the ICC or the AAA or the LCIA. They, on their website, have a model arbitration clause. That clause is the product of careful collaborative work, often accumulated over decades. It has seen multiple hands in perfecting its drafting. It may not be perfect in every case, but in every case, it's almost certainly better than what one can do by reinventing or seeking to reinvent the wheel. My typical advice is, absent exceptional circumstances confirmed by expert advice of some sort, parties should agree to institutional as opposed to ad hoc arbitration. They can choose amongst the many excellent institutions that exist both in this region and elsewhere. Having chosen an institution, use its model arbitration clause. Deviate from that clause only with considerable caution and with a compelling reason to do that. If you deviate from the clause, you'll need to explain why you did it and what the consequences of that deviation are. You may very well introduce inconsistencies or mistakes. Most model arbitration clauses are drafted quite broadly by intent and work. They produce, assuming the parties evidence their valid consent, valid arbitration agreements. And therefore, consistent with my motto of KISS, using those institutional arbitration clauses is, in my view, the safest, the wisest course.
Thank you, Gary. Let's now move to the multi-party arbitration and procedural complexities. And my question would be about what are some common legal challenges or objections raised against consolidations and joindering in arbitration proceedings?
That's an excellent question, and one that is very timely. The ICC's statistics on multi-party arbitrations indicate that nearly a quarter of all arbitrations, perhaps more in some years, are multi-party. So that means when we think about arbitration agreements, very oftenly we think of agreements between A and B, party A and party B, when in fact the world is more complicated. In fact, the world very often today has both multi-party but also multi-contract disputes. Contracts that are between not just A and B, but between A, B, C, D, E, and F, in often complicated relationships. Commercial transactions today tend to be complex, and parties can have equally complex roles depending upon the ingenuity and creativity of corporate lawyers. One can also have multiple agreements that affect the same relationship. Think about project finance, think about joint venture, think about many types of sales arrangements where multiple contracts exist. And in all these cases, arbitrations can arise when disputes arise. If the parties have included arbitration clauses in a multi-party contract or in the various multiple contracts in a multi-contract relationship. And the types of disputes that can arise are obvious. In a contract involving multiple parties, the claimant, let's say A, may choose to bring an arbitration against several respondents, B, C, and D. And those parties may argue that they're only obligated to arbitrate in a bipartite, not a multi-party arbitration. And tribunals, also arbitral institutions, need to address those rules. For the most part, arbitral institutions and tribunals, also national courts, have had little difficulty concluding that if you have an arbitration agreement in a contract between multiple parties, that agreement binds all the parties and permits one party to commence arbitration against any or all of the other parties. It could start an arbitration against just B, or it could start an arbitration against B, C, D, and E, the way I described it wished to, and that would be nonetheless an arbitration brought under a valid arbitration agreement. But life can be even more complicated, of course. It can be more complicated because A might choose only to bring an arbitration against B, but C, D, and E might wish themselves to join that arbitration, or alternatively might start a separate arbitration against A or perhaps B. And there might be an effort to consolidate that separate arbitration with the initial A versus B arbitration. At the end of the day, the ability of either new parties to intervene in an existing arbitration, C, D, and E joining the A and B arbitration, or alternatively to consolidate two separate arbitrations, depends on the parties' consent. Absent consent, there can be no arbitration. The arbitral tribunal has no jurisdiction. And so the question then becomes, have the parties consented to either intervention or joinder of new parties in an existing arbitration, or alternatively, to consolidation of two or more arbitrations into a single arbitration. There may be compelling practical reasons, pragmatic reasons, to permit intervention, joinder, or consolidation. It makes more sense to have one arbitral tribunal, pay one set of arbitrators, have one set of proceedings with one evidentiary record than to pay multiple tribunals, multiple sets of lawyers in multiple different arbitrations. But ultimately, it's not just a question of efficiency, it's also, as your question suggests, a question of consent. Historically, many institutional arbitration rules and also national arbitration legislation didn't provide mechanisms for joinder, intervention, or consolidation. And some national courts declined to permit that. And the ICC, for example, historically would not permit the intervention or joinder of new parties, much less the consolidation of arbitrations. The world has changed. We're in the 21st century. I think thankfully, I'm not always positive, but I think thankfully. And what we can be thankful about for sure is that most institutional rules today have relatively sophisticated mechanisms for accomplishing all three of the things that we've been discussing: joinder, intervention, and consolidation. Those rules need to be complied with, and they have various limitations on the circumstances in which parties can be joined or permitted to intervene. Arbitrations can be consolidated. Ultimately, one needs to satisfy whatever those specific technical requirements are. They tend to be fairly liberal today, and they tend to permit consolidation as well as joinder and intervention, assuming that you have parties all bound by the same arbitration agreements or closely related agreements. Then there's very often a way to achieve a more practical, efficient, and expeditious dispute resolution mechanism.
On the flip side, when rejecting consolidation and joinder to be considered a pro-arbitration stance, okay, given the risks of conflicting decision, so would rejecting the consolidation and the rejoining be considered a pro-arbitration stance, given the risks of conflicting decisions?
So ultimately, I think it really is a question of the parties' consent. In some cases, the parties may not have consented to something that is the most efficient or sensible way to resolve their disputes. Parties might not have agreed to institutional rules that allow for intervention or consolidation. And in those circumstances, I would hesitate to say it is pro-arbitration nonetheless to permit joinder or to require consolidation. It is not pro-arbitration to impose what one thinks is a more efficient, a more pragmatic solution on the parties. Rather, what is pro-arbitration is to give effect to the parties' agreement. And if they have chosen a mechanism that does not permit consolidation or intervention and joinder, that ought not to be imposed on them. That said, I do think the following caveat is important. In many cases, particularly ad hoc arbitrations, it may not be clear what the parties actually intended. And if one thinks about this for a moment, that's hardly surprising. When parties conclude their contract, they don't expect there to be disputes at all. Exactly. It's part of the reason many arbitration agreements are poorly drafted. They don't think they'll ever need to use them. And if they don't think much about their arbitration agreement, you can be quite sure that they don't think much about issues like consolidation, joinder, and intervention. And as a consequence, what one must do is attempt to construct what the parties objectively would have considered the correct solution in these cases. What is it, absent an express choice by the parties, one should imply their agreement to be? And I would suggest in those circumstances, a more liberal view with respect to consolidation, possibilities of joinder and intervention makes sense. It makes sense provided that all the parties are bound by the same or related arbitration agreements. And in those circumstances, one should, just as they've agreed to arbitrate, conclude that they have impliedly agreed to arbitrate in a sensible and efficient fashion, namely one that permits consolidation, joinder, and intervention.
How do different jurisdictions approach these issues? And also, what are the implications for international arbitration?
It's an excellent question. In truth, there are limited authorities on this in most countries. Most countries, often by way of general principles, will recognize the principles that I have described already. Most jurisdictions will address at a very high level, an abstract level, issues of consolidation, joinder, and intervention by reference to the fundamental importance of parties' consent. They'll therefore say, but not say much more than consolidation, joinder, intervention, both can be and must be ordered where that is what the parties have agreed. However, most jurisdictions do not then explore what it means to conclude that the parties have reached an agreement on any one of those things. And as we've seen, in most cases, arbitration provisions, arbitration clauses don't address any of these issues. So what's really critical is what's missing from most national court authorities, namely, how is it you decide when the parties have agreed one thing or a different thing about consolidation, joinder, or intervention. A few countries, I'm thinking the Netherlands, I'm thinking New Zealand, I believe British Columbia, have national legislation that specifically addresses these issues. In some cases, the legislation, for example, there's Massachusetts state legislation in the United States that actually permits consolidation absent consent, which is a rather unique and unusual approach. Other jurisdictions, the Netherlands, New Zealand, permit consolidation typically at the order of national courts, sometimes by arbitral tribunals. But these jurisdictions also do relatively little to explain when it is one will conclude that the parties have authorized either consolidation or joinder and intervention.
In your opinion, so let me link both together. In your opinion, what are the best practice for drafting arbitration agreements involving multiple parties to minimize the risk of legal challenges?
And exactly that point, I think, underscores part of the advice that I gave previously. Namely, institutional arbitration is in most circumstances preferable to ad hoc arbitration. Part of the reason is, as I said a few moments ago, institutional arbitration rules today almost always address issues of consolidation, joinder, and intervention. And they therefore, unless the parties put something odd into their arbitration agreement that would override those provisions, which they hardly ever do, those rules then provide predictable, clear guidelines, rules, as to how consolidation, joinder, and intervention can occur. It is possible to, of course, draft from scratch provisions with respect to intervention, joinder, consolidation. I have a book. It's called International Arbitration Agreements and Forum Selection Clauses, Drafting and Enforcing, and it indeed offers some model clauses along those lines. However, in my view, it is unwise to attempt to use either clauses like that or clauses drafted out of whole cloth when one has institutional arbitration rules that have been tried and tested on many occasions by the institutions in question.
You're not doing a proper marketing for the book then.
There are other parts of the book that I would urge people to read. All my marketing on books these days has been focused on The File, the spy thriller.
Exactly. Friends of mine saying that, have you read the book? I said, no. I said, every lawyer has read the book.
I hope.
Okay. Turning into the interplay between party autonomy and state sovereignty. How do cultural differences influence the limitation on party autonomy in the arbitration?
So that's an excellent question, Saad, and it usually arises in the context of so-called non-arbitrability or objective arbitrability. As you know, as your viewers know, both Article 2 of the New York Convention and Article 5.2 of the Convention have so-called non-arbitrability exceptions. They provide in substance that an agreement to arbitrate need not be enforced where the subject matter is not capable of settlement by arbitration. And then conversely, in Article 5.2 of the Convention, a foreign award need not be recognized if it deals with a subject matter that is not capable of settlement by arbitration pursuant to the laws of the recognition forum. And so in each case, the reference in the Convention is to a category of disputes which, notwithstanding an otherwise valid arbitration agreement, the subject matter of these disputes isn't capable of settlement by arbitration, i.e. is non-arbitrable. And importantly, it is national law that defines this issue. The reference in Article 5.2 of the Convention is specifically to the law of the recognition forum, the place where the award is sought to be recognized. And so it's not cultural so much as legal. Different national jurisdictions are, by the New York Convention, expressly given the authority to define certain types of disputes as not arbitrable. Most countries have exercised that sovereignty in a quite limited and restrained fashion. For example, criminal law matters, some bankruptcy matters are not capable of settlement by arbitration. In some countries, issues with respect to domestic relations, the status of a marriage, for example, inheritance issues, perhaps, in different jurisdictions may be regarded as not capable of settlement by arbitration, as non-arbitrable. The theory is that they are so bound up with national public policy that an arbitral tribunal cannot be trusted to resolve those disputes in a final and binding manner. Fortunately, in my view, most countries have, as I say, exercised that authority in a very restrained, a very moderate fashion. There are a few examples that are to the contrary, but the overwhelming majority of cases involve quite extreme subject matters. And as a consequence, the overall approach of most national courts has, in this sense, been pro-arbitration, giving effect to parties' arbitration agreements and only forbidding parties from exercising their autonomy in a very limited scope.
Good. Well, actually, this was also answering my second question, which was about the pose of threat, if the arbitration actually could pose a threat on the state's sovereignty and how these states typically respond to such a concern, which is you just answered. So my next question is, how can parties balance the principle of party autonomy with the need of the respect of the state's sovereignty, particularly in the investor-state disputes?
So my previous answer was focused very much on international commercial arbitration and of course the New York Convention. The investment arbitration, particularly ICSID Convention arbitration, is slightly different. It's different because, in contrast to Article 2 of the New York Convention and Article 5.2 of the Convention, there is no non-arbitrability exception. Rather, it is entirely a question of consent, perhaps because the parties one of the parties that must consent in an ICSID investment arbitration is the state itself. And perhaps the thinking is that where a state consents to arbitrate, then one needn't have an additional non-arbitrability or public policy protection for the state's interests, for the state's sovereignty, so to speak. The state itself should be permitted to decide what it wants to arbitrate, and no other party outside the state should second guess that choice, in a sense, saying that certain things the state agreed to arbitrate should actually be considered non-arbitrable in an odd way, in an ironic way, doing that might actually infringe state sovereignty, state freedom to agree to arbitrate various things if a third party said, well, actually, you might have agreed to that, but you can't. You, the state, are not permitted to do that. And so the approach in investment arbitration is not to have a rule of non-arbitrability. Does this, one might ask oneself, fail satisfactorily to protect the state's sovereignty, for example, over some of the matters that I described previously, issues of say, criminal jurisdiction or of state authority over domestic relations, or similar types of matters? I would suggest not, both for the reason that I gave previously. States are the best guardians of their sovereignty, and when they agree to arbitrate, that agreement should be respected, not second-guessed, but also because the public international law investor protection rules as a substantive matter contain within themselves, having of course been made by states, protections for state sovereignty. They contain protections for the state's right to regulate the state's police powers and the like. Some bilateral investment treaties have within them exclusions for certain types of topics, national defense, national security, these sorts of things. And states are of course free to negotiate other types of exceptions should they think that is important. And therefore, I think in the context of investment arbitration, the mechanisms that one deals with, the structure of bilateral investment treaties, the involvement of states, contain more than sufficient protections for state sovereignty. I think a more interesting question, perhaps, or another interesting question would be, should international law impose limitations itself on a state's ability to create exceptions to its arbitration agreement? A state's effort unilaterally to exclude certain topics from arbitration, at least arguably, would be inconsistent with both the New York Convention and the ICSID Convention.
Perfect. Let's now move to the role of the private international law, BIL, or PIL. So what point does BIL become critical in arbitration proceeding, and also particularly in a complex cross-border disputes?
That's a very important and very frequent question. And the answer is that private international law, as it's sometimes called, is important from the very beginning until the very end of both the arbitral process on the one hand, but also international dispute resolution more broadly. And let me try to explain both those points. First, private international law, if one by that means conflict of laws, choice of law on the one hand, issues of jurisdiction on the other hand, is ubiquitous or pervasive throughout the arbitral process. I referred previously to needing to choose the law governing the international arbitration agreement. That involves choice of law rules. One looks in books such as Dicey, Morris, and Collins on conflicts of laws and finds hefty chapters on the law governing the international arbitration agreement. Once one gets into the arbitral process, private international law concepts, again, principally choice of law, apply with respect to choosing the substantive law governing the party's underlying dispute, whether it's a contractual dispute, what law governs the contract, or a non-contractual dispute, what statute applies, what law applies to delict or tort claims. It also applies to issues of procedure. What law governs issues of procedural fairness? What law governs questions of privilege in disclosure, and the like? And thus, private international law rules and concepts are important throughout the arbitral process. I mentioned that there's a second aspect to how private international law is important in international dispute resolution. And that is as follows. Every international dispute is at least potentially subject to arbitration, but also litigation in national courts. Parties not infrequently, having previously agreed to arbitrate, decide perhaps that's not such a good idea. They've agreed to arbitrate in part because they want an expert, efficient, and expeditious dispute resolution process that will be enforceable. I sometimes call these the 5 E's. But once a dispute actually arises, one party may decide the last thing it wants is an enforceable decision by an expert in an expeditious fashion. It would rather that there never be any resolution of the dispute, or that any resolution turn out not to be enforceable, not to be final and binding. And thus it may seek to, instead of arbitrate the dispute, litigate it somewhere. And often the somewhere is its own home courts, where it hopes it may have advantages that it wouldn't have in the arbitral process, the international arbitral process. That inevitably then raises questions of jurisdiction. Is there jurisdiction over the person of the respondent in the claimant's chosen courts? To what extent will those courts respect the agreement to arbitrate, assuming that they have some sort of jurisdiction? To what extent can courts in other jurisdictions be...
I love this. I love that you are asking the questions. You're reading my mind.
I'm taking your job. Perhaps you answer. To what extent might courts in another jurisdiction issue a so-called anti-suit injunction to prevent courts in a different country from interfering with the arbitral process? To what extent might those anti-suit injunctions be respected or not respected in other jurisdictions? And so issues of PIL, as you rightly put it, can come up in multiple ways in the arbitral process.
It's very critical role. But going again back to a role you spoke about, determining the applicable law for arbitration, but I would like to understand what role could PIL play in determining the applicable law for arbitration agreements, which could be also involving multiple jurisdictions.
Okay, so imagine that one has a contract governed by English law with an arbitral seat in France, and issues arise as to the existence or validity of the arbitration agreement. What law governs that arbitration agreement? Is it English law because the parties chose English law to govern the underlying contract? They have a choice of law clause in their contract that provides this contract shall be subject to the laws of England and Wales. Or is it French law because the parties chose to seat their arbitration in France? This is actually not a hypothetical. This is a real case. It's a case called Kebab versus Kout Food Group. And it was decided both by the UK Supreme Court on the one hand and the French Cour de Cassation on the other hand. They reached opposite conclusions. The UK Supreme Court, consistent with at least some UK authority, not in my view the better reasoned English authority, but some English authority, concluded that a general choice of law clause applies also to the separate, the autonomous arbitration agreement. In contrast, the French Cour de Cassation, in an action to confirm the award made in Paris, made in France, reached the opposite conclusion, reached the conclusion that the arbitration agreement was governed by the law of the arbitral seat. That means French law, and in particular, French international arbitration law. And thus, that case is a very good example of how different courts, applying their own PIL rules, reach different conclusions with respect to the law governing the arbitration agreement. Importantly, there's a happy ending to that thus far unhappy story in Kebab G. The happy ending, perhaps not for Kebab G and Kout Food Group, but for the international arbitration world more generally, is that the UK Law Commission recommended overturning the decision in both Kebab G and an earlier case called Inca versus Chubb Insurance Company, and providing that absent an explicit choice governing the arbitration agreement itself, explicit choice of the law to govern specifically the arbitration agreement, that agreement would be governed by the law of the arbitral seat, not the underlying contract. And legislation to give effect to that recommendation is expected to pass in the UK Parliament in the very near future. In my view, that is the correct outcome. It is the correct approach towards the law governing the arbitration agreement, and the errors of the UK Supreme Court will shortly be remedied.
Good, that's good. Moving away a little bit from the courts and speaking about the tribunals on the same subject, how do tribunals manage conflicts between the substantive law and the contracts and the rule of private law?
So tribunals, as we know, arbitral tribunals, as we know, have quite broad substantive decision-making authority. With respect to procedural matters and the validity of the arbitration agreement, tribunals are bound by, of course, the parties' agreement and subject to at least a degree of national court scrutiny. Did they correctly or incorrectly decide the question whether there is a valid arbitration agreement? With respect to substantive disputes, does this contract impose an obligation to deliver the goods at a particular time in a particular condition or not? Tribunals have quite broad authority. Their mandate, of course, is to give effect to the parties' agreement, applying the law that the parties have chosen to apply to that agreement. But there's virtually no national court review of the substance, the merits of their decision. Tribunals, in my view, properly give enormous effect to the terms of the parties' agreement. They seek to effectuate the parties' commercial bargain. They will, of course, look at that agreement, that bargain, in the light of the applicable law. They will attempt to apply to the best of their ability private international law rules to select the substantive national law that governs the contract or the non-contractual claims, and they will give effect to that law. I think inevitably there is a bit of a tilt towards giving effect to the parties' agreement if there should be some conflict between that and a putatively applicable national law. In part, I think that is because of the nature of arbitration. It arises out of commercial dealings, and I think there's therefore quite substantial respect for the parties' commercial bargain, and perhaps I wouldn't say less respect, but that the parties' commercial agreement is given respect even in the context of national legislation or judicial decisions that might be less enthusiastic about giving effect to the parties' agreement. I think arbitration really does seek to effectuate the parties' bargain. Now, arbitral tribunals will, if national law invalidates a particular type of provision or mandates that it be interpreted in a particular way, they naturally will respect that. But I think importantly, tribunals are quite respectful of the parties' commercial bargain, and in my view, rightly so.
So, Gary, fairness is a cornerstone of arbitration. What key issues in arbitration could impact the fairness of proceedings?
Fairness is indeed, as you say, a critical aspect of international commercial arbitration, also in investment arbitration. One of the basic requirements of the UNCITRAL model law, Articles 18 and 19, is that both the parties' agreement with respect to arbitral procedures be given effect, but also importantly that the parties be treated equally and be given a full opportunity to present their case. Articles 34 and 36 of the model law, as well as Article 5.1b of the New York Convention, also guarantee the parties' right to be heard, an opportunity to present their case, and permit non-recognition or annulment of arbitral awards where that right hasn't been respected. What are the key examples where a party may be denied equality of treatment or alternatively an opportunity to present its case. There are multiple different ways that one or both of those rights can be infringed in slightly different manners. One way, obviously, is a lack of notice. If a party doesn't receive notice of the arbitration at all, which is unusual but not unheard of, or doesn't receive notice of important things in the arbitration, for example, for whatever reason, an arbitral tribunal might not communicate something to the parties, some substantive matter that it has taken into account. That may involve both an inequality of treatment, depending on how the other party was informed or not, but also a denial of an opportunity to be heard, because if you don't know that you need to speak, then you'll never be heard. Other important examples involve situations where a tribunal doesn't permit a party to make submissions on a particular issue or to submit evidence on a particular issue when doing so is necessary. For example, if a counterparty changes its case late in the proceedings, and a tribunal both permits that to be done, but also does not permit the opposing party to respond in some fashion, either with evidence or legal submissions. Obviously, deciding when an amendment or a change of case is permitted is something within the tribunal's procedural discretion, as is the question of how a counterparty should be permitted to respond. Nonetheless, where a tribunal abuses this discretion, it may well result in either inequality on the one hand, or alternatively unfairness, a denial of an opportunity to be heard. Cutting off questioning of a party at a hearing. Tribunals, quite properly, are interested in ensuring efficient arbitral hearings and proceedings, and they therefore will often urge the parties to move along. In some cases, they may cut a party off, not permit it to present a witness on the theory that they don't need this evidence, or not permit it to cross-examine or continue cross-examining a witness. Tribunals need to be cautious when they do so. Efficiency is important, but an opportunity to be heard is also important. These are the main examples. There are, of course, other instances of unfairness, but these are the main examples that one encounters.
But have you encountered cases where agreeing to arbitrate actually turned out to be the wrong choice for the parties?
Very much so. I've encountered cases where parties agree to arbitrate, and then it turns out their substantive defense is entirely without merit. They have a terrible defense. The arbitral tribunal very quickly appreciates this, very quickly makes an award against them in a very large amount of money. The award is subject to recognition and enforcement under the New York Convention, not just in the award debtor's home jurisdiction, but 170 different countries around the world. That party should not have agreed to arbitrate, because arbitration made its breaches of its obligations fully enforceable against it.
Yeah. In cases where an arbitral award is enforced in a state despite being set aside by the court of the seat, do you think that this contradicts the parties' initial agreement and their choice of the seat?
That's a very nuanced and sophisticated question.
You are here today to answer all the hard and sophisticated questions.
This one is a very thoughtful question. We all know the basic proposition under the New York Convention and otherwise. That proposition is that an award must, in principle, be recognized outside of the arbitral seat in other countries that have acceded to the New York Convention. And so, just to take an example, if an award is made in state A, it's subject to recognition in states B, C, D, E, and F all around the world under under Articles 3 and 4 of the New York Convention, subject only to the exceptions in Article 5 of the New York Convention. One of those exceptions in Article 5 is where an award has been annulled in the arbitral seat. That would, in my example, be State A. And the question has arisen in many cases. Suppose that the courts in State A set aside the arbitral award. Can it nonetheless be recognized and enforced under the New York Convention in states B, C, D, E, and F? And most courts have said in principle, yes, on the following theory. The New York Convention in Article 5 sets forth grounds on which a court in a contracting state may, but need not mandatorily, deny recognition of an award made in another contracting state. So what that means, put simply, is if an award is annulled in State A and taken to State B for recognition, State B has an obligation to recognize that award, but is permitted, because of the exception in Article 5.1e for awards that have been annulled in the arbitral seat, to deny recognition. It is relieved of its obligation to recognize the award, but importantly, is not subject to an obligation to deny recognition of the award. It is left free to decide whether or not to recognize the award. And courts in a number of jurisdictions have concluded in those circumstances that they will, in fact, recognize an arbitral award that has been annulled, in particular in cases where they have doubts about the fairness of the annulment proceeding in the arbitral seat or the grounds on which the arbitral award was annulled. For example, exceptional local grounds that permit the courts of the arbitral seat to revisit entirely the substantive conclusions of the arbitral tribunal. And now your question, quite interestingly, focuses on whether that recognition in State B of an award annulled in State A is inconsistent with the parties' arbitration agreement. That's a much more interesting argument than some other people have made. Some professors from the continent in Europe, I think Netherlands, I forget exactly where, have taken the view that an arbitral award that has been annulled in the arbitral seat isn't there anymore. There's no more award. It's been erased from human history, and therefore there is no award to be recognized in State B. That view is, with respect, silly. It's silly because the New York Convention treats
That's
that
why
award.
That's why I don't remember the names.
That is perhaps the reason why. Perhaps, but obviously the award is still there. It hasn't been erased from human history. Indeed, the New York Convention in Article 5.1e treats its annulment as an optional ground for non-recognition, not a mandatory ground. And Article 7 of the New York Convention really underscores this, because it provides that nothing in the New York Convention detracts from a party's rights to recognize an award under national law, having specifically in mind the French approach, which is not to take into account the annulment of an award in the arbitral seat. So the notion that an arbitral award that has been annulled in the arbitral seat really isn't there to be recognized elsewhere doesn't make sense at all. What is a more serious argument, in my view, is that the parties, having agreed to seat their arbitration in State A, have therefore accepted what it is that State A's courts do in an annulment proceeding. And therefore, a court in State B shouldn't, even if it can, even if it's permitted to, recognize the award in State B. And I think although there are some attractions to that argument, at the end of the day, it's unconvincing. It's unconvincing because I think it assumes that the parties' agreement on State A as the arbitral seat ignores or excludes the possibility of recognizing even an annulled award. And I think the better view is that the parties' contract, their parties' agreement to seat their arbitration in State A doesn't address specifically what happens with annulled awards. You could imagine the parties agreeing that any award annulled in State A cannot be subject to recognition elsewhere. But parties never agree to anything like that. Their arbitration agreement is silent. All it does is seat the arbitration in State A. So the question is, what should you imply into their arbitration agreement? Should you imply that the courts in State A can decide once and for all for the entire world whether or not the award can be recognized in States B through Z? Or should you imply the view upheld by virtually all national courts thus far that even if set aside in State A, an award may nonetheless, in some circumstances, be recognized outside State A in States B through Z? I think the latter approach plainly makes more sense.
Perfect answer. Thank you so much, Gary. Let's move to the tribunal side and how the tribunal balanced the party autonomy with the public policy considerations. Here we talk more about the public policy when actually determining arbitrarity, and particularly in the cases of disputes deemed not arbitrable due to the public policy concerns.
Yes, this is a relatively exceptional circumstance, but an important one when it does arise. Vast majority of cases, the question is interpreting what the parties' contract means without reference to overriding notions of mandatory law, rules of mandatory law, or principles of public policy. Neither party argues this provision of the contract is invalid or unenforceable because of national public policy. Nonetheless, there are cases where that arises. Liquidated damages provisions, non-competition provisions, other types of contractual restrictions may be challenged on the grounds of public policy. Virtually all private international law regimes recognize this possibility. And provide both for the rules of the law chosen by the parties, assume the parties choose the laws of State A to govern their contract, the public policy of State A to override some contractual term of the parties' agreement, or in more limited cases, the laws of some other jurisdictions. The parties choose the law of State A to govern their contract, and one party says the public policy of State B or State C overrides some provision of the contract, even though the laws of State A, the public policies of State A do not. And those are very challenging circumstances for the arbitral tribunal. In most cases, as I suggested previously, arbitral tribunals have particular respect for the parties' commercial bargain, and therefore, I think, are reluctant to apply public policies, whether they be that of in my example, State A, the law chosen by the parties, or some other state, but nonetheless will, where the public policy is clearly defined and plainly applicable, apply those public policies to override provisions in the parties' agreement. There are some who argue that arbitral tribunals should not do this, that arbitral tribunals are purely a creature of contract, and that they're not mandated to apply mandatory law or public policy. In my view, that's incorrect, that's inaccurate. Arbitral tribunals are mandated to give effect to the parties' agreement as interpreted in accordance with applicable law, almost always that chosen by the parties themselves. And therefore, the tribunal doesn't deviate from the parties, doesn't ignore the parties' agreement when it gives effect to public policy. It rather gives full effect to the parties' agreement, including its choice of law clause. And I think that rationale is more difficult, more nuanced, in the case of applying the public policy of a jurisdiction not chosen in the parties' choice of law clause. So in my example, the parties subject their contract to the laws of State A, but one party argues that the public policy of State B overrides the terms of the parties' contract, arguably overrides the laws of state A. I think there can be circumstances where the parties' agreement contemplates exactly that they agree to arbitrate all disputes arising from their contract. They have necessarily given the tribunal the authority to choose the applicable law, including public policies. There can be circumstances where those applicable public policies will be different from the law chosen by the parties to govern their contract. And so in that sense, the parties' agreement contemplates exactly what seems to contradict their agreement, namely application of a foreign public policy. But that is, in my view, the proper interpretation of their agreement.
Okay, so let's shift focus now to the provisional measures. We spoke about it at the beginning. So what is the current stance of national laws on granting arbitration or arbitrators the power to issue provisional measures? And also let me ask the second question with it, because I'm sure it will be connected. Do you think that the enforcing of these provisional measures as a final award could deprive parties of their rights to appeal?
Excellent questions again, Saad. Thank you very much. The current state of national law with respect to provisional measures by arbitral tribunals is fairly uniform. Historically, there were a number of jurisdictions that denied arbitrators the power to award provisional relief. That has changed fairly radically. First, national laws outside the UNCITRAL model law began to give arbitrators expressly the power to order interim relief, the same way a national court would have the power to order interim relief. Courts in the United States, elsewhere, led the way in doing that. The model law began by doing that, and then in more extensive revisions authorized explicitly arbitral tribunals to grant interim measures without prejudice to the power of national courts, also concurrently in parallel to grant interim relief in aid of arbitration. So that means that the parties' arbitration agreement gives presumptively the arbitral tribunal the authority to order provisional measures, but it doesn't take that away from national courts. And the model law, to some extent, like national law in other jurisdictions, again, the United States in particular, but other jurisdictions also, I think of India and Singapore, recognized the authority of national courts to enforce orders of provisional measures, albeit on an interim basis. Arbitral institutions acted to reinforce the ability of the arbitral process to provide interim relief, and established mechanisms typically called emergency arbitration, whereby even before an arbitral tribunal is constituted, a sole arbitrator, a so-called emergency arbitrator, could be appointed on a very fast-track basis, i.e. in 2 or 3 days, sometimes less than 1, with the mandate to hear applications for not just provisional measures, but emergency provisional measures that just can't wait, in a very short period of time, less than 10 days. And a number of EAs, emergency arbitrators, have in fact been appointed both under ICC, but also other institutional arbitration rules. I think of the Singapore International Arbitration Center in particular. And EAs have issued emergency arbitrator awards, which have been recognized and enforced in a number of jurisdictions, including Singapore, the United States, elsewhere. I don't think that this deprives parties of an opportunity to have a final award. I think it maintains the status quo so that an arbitration can proceed without one party effectively losing the case simply because arbitral awards, final awards, inevitably take months, sometimes years, to be obtained, and a party may go bankrupt or lose valuable rights in the interim. Interim award just affects the provisional period, between when it's granted and the making of a final award. And so I think both the existence of emergency arbitrators, but also the provisional measures authority of arbitral tribunals is a good thing. It's virtually uniformly recognized around the world. I think China is about the only country now that doesn't recognize it. I think Italy and Argentina historically didn't. I think Italy has changed its view, and I'm not entirely sure about Argentina.
Talking about the enforcement of the provisional measures, how different jurisdictions approach in relation to the enforcement of the provisional measures, and also what the challenges arise in the cross-border context.
Yeah. So some countries, Australia is a leading example, take the view that the New York Convention and also their national arbitration legislation apply to awards. And that means final awards that finally resolve the parties' dispute. And they say an interim award, or sometimes they say order, can't be an award. That's why they sometimes say order. An interim award can't be an award because it doesn't finally decide anything. It, by its very nature, is provisional, it's interim. It necessarily expires when the arbitral tribunal makes its final award, and therefore we're not obligated to and won't recognize and enforce it. The United States and some other countries have historically taken a different view. They've said the concept of an award isn't so narrow. It can also apply to interim awards, in part because pragmatically it makes a lot of sense to be able to recognize interim awards if a party fails to comply. They're important elements of the tribunal's decision-making power, and they should be given effect even if only on an interim basis. My own view is that the latter view is the better view. But in any event, a number of countries have also begun to adopt legislation, and the model law reflects this. The revisions to Article 17 in the model law reflect this from the first decade in this century, providing a standalone enforcement mechanism for interim awards, even if one doesn't choose to regard them as final awards.
Good. Let me move now to another complexity, which is the non-signatories, because it's often complicated the arbitration proceedings. When and how can non-signatory party become involved in arbitration proceedings?
So, non-signatories are a curious creature. They are by definition non-signatories. They haven't signed a contract or an arbitration agreement, but the key issue that they give rise to is, can they nonetheless, despite the absence of having signed anything, be parties to an arbitration agreement? Can they be bound by an arbitration agreement, and can they be benefited by an arbitration agreement? That issue can come up in a variety of different contexts. It can come up when a party starts an arbitration. For example, can a non-signatory start an arbitration? Alternatively, can a signatory start an arbitration against, among others, a non-signatory? And the final context in which non-signatory issues can come up is at the award recognition and enforcement stage. Can an award made against a non-signatory actually be recognized and enforced against that non-signatory? And the answer in all of these cases is yes, but. Yes, non-signatories can be bound by an arbitration agreement and also benefited by an arbitration agreement, but not always. And critically, one has to look at a number of legal theories, legal doctrines that can be invoked, very frequently are, to bind a non-signatory to an arbitration agreement. These can include things like universal succession. Company A, it's a party to an arbitration agreement, merges with Company C that never signed any arbitration agreement. Is Company B, who signed the arbitration agreement with Company A, bound to arbitrate with the new merged entity, Company B? Answer, very frequently, yes. Rules of universal succession, consequences of a merger, permit, in effect, the transfer of the arbitration agreement from one party to another, the succession of one party to another. Rules of alter ego or agency. One party enters into a contract not as principal, but as agent for a different party, its principal. The principal typically is bound, even though it doesn't sign the arbitration agreement. Only the agent signs the arbitration agreement. In most national law rules of agency, the principal would be bound, notwithstanding its non-signatory status. And the same rule applies with respect to arbitration agreements. Alter ego status is treated similarly, as are a number of other legal doctrines, assignment, implied consent, and the like. And those issues can come up both before the arbitral tribunal and in national courts, and typically the rules and the issues are the same in both contexts.
Can you, what the challenges first arises in the enforcement of these arbitral awards that involve non-signatory? And also, can you provide some examples of cases where non-signatories actually were successful indeed, and what legal principles were applied?
So the classic issue that arises in award recognition contexts is under Article 5.1a of the New York Convention, or Article 34.2a1 of the UNCITRAL model law in an annulment, a set-aside context. Both those two sets of provisions allow for either annulment on the one hand or non-recognition of an award on the other, where there was no valid agreement to arbitrate. And what does it mean not to have a valid agreement to arbitrate? It means a valid agreement between the parties who are bound allegedly by the arbitral award. And so if a non-signatory is the respondent in a case, unsuccessfully challenges before the arbitral tribunal its participation in the arbitration, says, I'm not bound by the arbitration clause, tribunal should dismiss the arbitration against me. Tribunal refuses. Tribunal says, you're an alter ego, or you're a principal that is bound by the agent's acts, and makes an award against this party. That party then can argue in a subsequent annulment or recognition proceeding, I wasn't a party to the arbitration agreement. I didn't sign it. I'm not bound by it. The award can't be recognized against me. It must be annulled because there was no valid arbitration agreement that bound me. And courts in a number of cases have accepted that conclusion. A good example, you asked for examples, is a classic Swiss case involving Westland Helicopter on the one hand, and then a consortium of Middle Eastern countries, including Egypt, on the other hand. And the consortium members, the countries, the nations that were parties to the consortium, said that they hadn't signed the arbitration agreement. They were non-signatories. And the question was whether or not they would be bound by an award. The tribunal rejected that argument, by an award. And the Swiss Federal Tribunal ultimately, after fairly lengthy proceedings, concluded that they would not be bound, that the non-signatories were not bound by the award that had been made against them.
Interesting. Okay. Can you share, let me move here to some personal insights, okay, without breaching confidentiality when I was naming Can you share particularly challenging cases you have worked on and how you approach it?
So two of my both particularly challenging but also favorite cases were Eritrea versus Yemen, where I represented Eritrea against Yemen, and the Abyei arbitration, where I represented the Sudan People's Liberation Movement /Army against Sudan. And just a word very briefly about each. The Eritrea-Yemen arbitration arose out of a dispute between Eritrea and Yemen over territorial sovereignty and maritime rights with respect to a couple islands at the very southern tip of the Red Sea, the so-called Zucker Hanish Islands, not too far from here, actually. Zucker and Hanish, I understand, mean antelope and turtle in Arabic, at least some versions of Arabic, because that's the only thing that's really on the islands. There tragically is no petroleum or any other natural resource. And there's no water as well, so they are uninhabited. The issue in the case was which country, Eritrea or Yemen, had territorial sovereignty over these islands. To which country did the islands belong? And as I mentioned, I represented Eritrea. We performed extremely extensive historical research. We worked through the archives in both Yemen and Ethiopia and before it Italy, and before Italy, Great Britain, with respect to historic governance of the islands. We looked through Ottoman tax records because supposedly Yemeni rulers had taxed the islands. It turned out that the zucker that they had taxed was actually in Anatolia, not in the southern Red Sea. We looked at how Italian secret agents had, bizarrely in fur coats, been on an expedition to the islands just prior to World War II, Eritrea claiming title to the islands via Ethiopia, which Eritrea had formerly been a part of, and in turn, Italian colonial authorities in Ethiopia at the time. Unfortunately, the secret agent missions also were not a particularly solid basis for finding acquisition of the territory under public international law. I've always thought that in a case, if you can't explain your case to a child of 6 without making up facts or distorting things, but explaining the case honestly and straightforwardly to a child of 6, if you can't convince the child so that at the end of the conversation he says, "Yes, Dad, you're right," then you've got a problem with your case. I tried to explain my case to my son, who at the time was 6 years old, and he looked at the map I drew, showed him of the Red Sea, and he said, "Dad, if you draw a line down the middle of the Red Sea, where are the islands?" And I did that for him, and the islands, unfortunately, were on the Yemeni, not the Eritrean side of the map. He said, "Dad, this is a very easy case." I'd spent hundreds of hours. My team had spent thousands of hours in historical archives. My 6-year-old son said, "This is an easy case. If it's on the Yemeni side of the line, then it's Yemeni. If it's on the Eritrean side, it's Eritrean." Unfortunately, the arbitral tribunal, although it didn't say so much, pretty much came out where my 6-year-old son did. And it struck me that there's an important lesson in that case. My other most favorite case is the Abyei arbitration, which I mentioned, where the issue was what was the scope of a territory and what was then the center of Sudan called the Abyei area. And after very lengthy submissions to a quite distinguished arbitral tribunal, the SPLMA mostly won its case. I think the evidence from community members of how historically they had used the Abyei area for their religious, for their family, for other reasons was quite compelling in that respect.
Wow, this is really interesting. I'm sure that this investigation also inspired you to write the files, because the spy mission, right?
It oddly enough did have some impact on the file.
Good. Right. Have you ever faced a situation where the tribunal jurisdiction was challenged?
Many cases.
How did you handle it?
So I have both been counsel in arbitrations where the opposing party challenged jurisdiction, in a couple cases where we challenged jurisdiction. I've also been on tribunals that have had jurisdictional challenges presented to them. The common procedural issue that arises in those cases is whether one should first and separately hear the jurisdictional question, so-called bifurcation, and then only subsequently consider the merits, or whether one should consider all of the arguments together. I, in general, lean towards, as a principle, not as a rule in all cases, but as a presumption towards either not bifurcating, or alternatively, if one does bifurcate, to bifurcate without delaying merits submissions on the basis that various empirical studies have shown that bifurcation quite significantly increases the overall costs and expense of the arbitration. Those are studies from investor state cases. And my view that it is important not to slow down what is meant to be an efficient and expeditious dispute resolution process in order that jurisdictional challenges can be heard. I fully take the point that if jurisdiction can be rejected, if a party objecting to jurisdiction proves to have the correct position, then you don't need to go on and decide merits, but one can do that by having jurisdiction decided in parallel with submissions, at least initial submissions on the merits. One can obtain both expedition and efficiency without delaying consideration if there is jurisdiction of the merits.
Yeah, well, that's interesting. Another question about also your personal experience. What are some of the most complex procedural issues you have encountered, and how do you resolve them?
That's a good question, and it goes back to some of the questions you asked previously about multi-party arbitrations. I think uniquely complicated procedural issues can arise in cases where you have three or frankly sometimes more parties who don't have just traditional claimant-respondent claims, but who have claims in all, if I can put it this way, in all directions. So suppose you have parties A, B, C, and D. It's not just that A is suing B, C, and D. It is that A has claims against B, C, and D, but B has claims against A as well as against C and D perhaps has claims not against A, but against B and C. And the reason that this is very difficult is that one needs to come up with a procedural timetable, both for submissions, but also for the hearing itself, that is on the one hand efficient and expeditious, but on the other hand gives everybody a full opportunity to both present their case, but also respond to the other party's cases. And when you have multiple claims going in all directions, a sort of classic university food fight, then one needs to work very hard to come up with a sensible procedure.
Yeah. So let's talk a little bit about the future. So let's end by the future. And looking ahead, how do you see the technology evolving in international arbitration?
So technology has transformed international arbitration over the last several decades. There was a time, if one thinks back to the 1960s, 1970s, or for that matter, even the 1990s, when arbitration was one of the main sources of business for courier companies like DHL or Federal Express or what have you. Arbitration was conducted by fax and by courier, occasionally by telephone, although telephone conference calls weren't really a thing. Hearings were in person because that's the only way you could have a hearing. The world transformed in the last 20 years, and particularly during and following COVID-19. Emails, at first prohibited by the ICC as a means of transmitting submissions or awards, became the only permitted means of communicating. And in due course, hearings stopped being, at least in some cases, in person and began to be hosted on virtual platforms, whether Teams or Zoom or something else. During COVID, that was the only way you could, in most instances, have hearings. And arbitration, international arbitration, didn't at all stop the way some national courts stopped during COVID. It continued. Caseloads increased. More hearings were conducted. People sometimes had objections to virtual hearings. They sometimes thought they didn't provide a full opportunity to be heard. National courts almost uniformly rejected those kinds of objections, in part because at least many of them were having their own virtual hearings. And the international arbitration community discovered that you could have virtual hearings just about as well as you could have in-person hearings. Post-COVID, for smaller hearings, often without witness testimony, virtual hearings have continued to be very common. in particular for procedural conferences, for closing hearings, closing submissions, for short interim applications and the like. Virtual hearings are the rule, the norm, as opposed to in-person hearings. I expect all this to continue and to become more sophisticated. I think technology to allow virtual conferencing continually improves. And I think ultimately one has to compare the experience, so to speak, of a very, very high quality virtual hearing with an in-person hearing. What is so special about being in the same room with somebody else if virtually you get much of the same sensory input? I think that's a question for the future and for future technological developments, but it's a very real question. The elephant in the room, of course, is artificial intelligence, and especially generative artificial intelligence. Lawyers have been using computers, algorithms, in international arbitration for a couple decades now. Most document discovery involves search terms and other computer-assisted applications that work better than people do at those sorts of tasks. And the question is, can generative artificial intelligence, AI, take over more of the task in international arbitration, both from a tribunal perspective, but also from a lawyer, a counsel perspective? I co-teach a course in investment arbitration with a colleague in the United States on the East Coast, and he recently gave one of his exams, not our exam, but one of his exams to AI. AI did better than more than half the class. Perhaps he had a bad class, but I suspect not. It's a very good law school. And it underscores the flexibility and the potential of AI. And perhaps if one's a lazy arbitrator, one asks oneself, well, if Professor X could give ChatGPT his exam question, why can't I give the record in this case and the issues presented to ChatGPT and ask it to draft an award? It could do that pretty instantaneously, actually, just the way it answered the professor's law school exam question. Why not have it give me a draft of the award? Of course, the award will be mine. I'll edit it, make sure it's fine, but what's the problem with that? I think there is, in fact, a very serious problem with that. Arbitrators cannot delegate their authority. And certainly if the arbitrator did that without notice to the parties, it would raise serious confidentiality issues. Who knows who has access to ChatGPT? But also delegation of power issues. And I don't, at least as presently advised, I don't think that disclosure can really cure that problem. The difficulty with disclosure with respect to AI is any disclosure has to be informed. And the truth of the matter is, I don't think people really understand how AI would go about deciding an issue like that, which my hypothetical arbitrator presented to it. What algorithm and what influences on the algorithm exist to provide the putatively objective answers that would be received? Are there hidden cultural, national, legal, other biases that absent being fully informed about, nobody could consent to? So I think that lies, if not in the very, very distant future, in some alternative universe which we don't inhabit. With respect to counsel, everybody has heard the anecdotes of counsel who used AI to draft their submissions. The submissions looked flawless, beautifully written, well organized, citing, unfortunately, to non-existent cases. AI made them up, which is a little bit the problem of the arbitrator using AI to draft an award. I personally don't.
The problem yet.
I personally don't have a huge difficulty, or perhaps no difficulty, with counsel doing whatever it wants with AI to conduct research, to perform review of witness statements, to do whatever. At the end of the day, the arbitral tribunal has to look at these things and decide, are these real cases? Are these valid submissions or not? And the fact that it was generated by AI or by a team of monkeys, chimpanzees, is neither here nor there. And thus, I have some hesitation with notions that there ought to be regulation of counsel's use of AI. In a sense, from my perspective on this issue, the proof is in the pudding. And if the pudding's bad or good, it doesn't matter whether AI was part of the recipe.
Yeah. So we can continue for hours and hours. And I'm sure that we will have to make another very near interview again to speak about aspects we did not speak about it, like conflict and other elements. But my last question, okay, are there any areas where you think arbitration needs significant reform to remain relevant and effective in global dispute resolution?
It's a very interesting question. And I don't think that there are. One might suggest that investor-state arbitration should be reformed. I think that ignores the fact that many of the so-called reform efforts, particularly in UNCITRAL's working groups, are not efforts that reform. They're efforts at destruction, aimed at eliminating arbitration. And I think for arbitration to accept those reforms would be to contradict, to betray its basic objective, its basic purpose, and that what arbitration ought instead do is to continue to be international arbitration, as it has been over the last decades for investor-state disputes, because states will, even if they periodically depart from time to time, always return to the fundamental premise that the rule of law is vitally important, particularly in the attraction of foreign investment, but also in all manner of dealings with foreign citizens. And I don't think that efforts to water down or destroy the objectivity, the efficiency, the expertise of the arbitral process should be either accepted or embraced by the arbitral community. Rather, remain true to the basic purpose and function of arbitration, being to objectively, in accordance with the rule of law, resolve investment disputes. That will always be and properly be in demand. So, Gary, thank you so much for sharing your invaluable insights with us. Your expertise and, to be honest, perspective truly enriched our understanding of international arbitration. So I cannot be more grateful for you to be here today. Thank you so much, Saad. It's been a pleasure. Thank you so much, Gary. And to our audience, thank you so much for tuning into this episode of the Ciarb in Arabic. Stay connected for more thought-provoking discussions with global leaders in arbitration. Goodbye and see you next time.